Law office, 11 p.m. I'm sitting here with a yellow legal pad and a case file that weighs almost nothing. That should have been my first clue. Voluntary manslaughter. State of Georgia ver. Marcus Alford. Filed September 14th, 2004. Chatham County Superior Court, Courtroom 2A, Judge Raymond Harmon presiding. Standard docket assignment through the public defender rotation. I wasn't appointed. I took it private because Marcus's mother called my office directly. Said her son didn't start the fight. Said he'd never been in trouble. In 24 years of practice, I've heard that exact sentence from about 300 mothers. They're almost never right. But Carol Alford had a church friend who knew my paralegal, and the case looked simple, so I took it. The facts were clean. Bar called the Rusty Anchor on West Bay Street. Friday night, August 29th. Two men arguing over a pool game. One punch thrown. Victim, Thomas Greenlee, age 31, stumbled backward, hit his head on the brass footrail at the base of the bar. Subdural hematoma. Dead before the ambulance got there. Marcus Alford was 24, no priors, 5'10", 160. Greenlee was 6'2", 220. The eyewitness statements were a mess. 3 said Marcus swung first, 2 said Greenlee grabbed him. The bar's security camera was 15 frames per second, pointing the wrong direction. You could see shapes moving. You couldn't see a fist. Arraignment was a Tuesday. Judge Harmon always ran his Tuesday docket fast. Standing lunch reservation at Elizabeth on 37th. Bail set at $150,000. Carol Alford posted it through a bondsman. Marcus walked out in the same khakis and polo shirt he'd been wearing when they booked him. Didn't say a word to me, just nodded. First meeting was at the county jail the following week. Conference room B. Fluorescent lights that buzzed at a frequency I can still hear. The room smelled the way every holding facility in Georgia smells. Industrial disinfectant over something you don't want to name. Metal table, metal chairs. The door locked behind you with a mechanical click that always made new clients flinch. Marcus didn't flinch. I set the case file on the table and opened my legal pad. I always take handwritten notes. I watch the client's hands while I write. In 24 years, I've cataloged the tells. The thumb rubbers, the nail pickers, the fist clenchers. You learn more from a defendant's hands than from anything they say. Marcus's hands were flat on the table, both of them, palms down, fingers still, not gripping, not relaxed, just placed there, like they were part of the furniture. They didn't move for the entire 45-minute meeting. We went through the standard intake. His version, Greenlee had been drinking, got aggressive over a missed shot. Marcus tried to leave. Greenlee blocked the door, grabbed his collar. Marcus swung once. He said he heard the sound when Greenlee's head hit the rail, said it sounded like dropping a bowling ball on tile. I told him the honest truth. Self-defense was a stretch. A jury might buy it, but might not. The DA would probably offer a plea. Involuntary manslaughter, 5 to 7. Better than 20. Marcus nodded, hands flat. Second meeting, 2 weeks later. I'd been in discovery, police reports, witness depositions, medical examiner's findings, standard work. But I'd found something useful. Thomas Greenlee had 2 prior assault charges. Both dismissed, both bar fights. The victim had a pattern. This was good for us. I hadn't told anyone yet. Found it that morning in the Chatham County Clerk's digital records. Hadn't written it in my notes. Hadn't called my paralegal. Conference room B again. Same buzz, same smell, same hands. We discussed strategy for 15 minutes. Plea options, timeline, what to expect at the next hearing. Then Marcus, without looking up from the table, said, "You're going to talk to Harmon about the prior." I stopped writing. He said it casually, not a question. A statement of fact about something that hadn't happened yet, referencing information I hadn't shared with anyone. I asked him what he meant. He said, "Greenlee's assault charges. You're going to bring it up with the judge. I told him I hadn't decided on that strategy yet, which was true. I told him I hadn't discussed the priors with anyone. He just nodded, hands flat. I drove back to my office and sat with it. Tried to rationalize. Maybe his mother's church friend had connections in the clerk's office. Maybe a deputy mentioned it in holding. Maybe Marcus just guessed. I wrote it off. I had 400 other things to worry about. A client who knew his own victim's record wasn't strange. It was convenient. I turned the page on my legal pad and moved on. That was my mistake. Not because I should have done something differently, but because what happened next would have been easier to process if I'd already accepted that something was wrong. 3 weeks before trial, I filed a motion in limine to exclude 2 of the eyewitness statements, inconsistent on timing, contradicted by the security footage. Standard motion. Judge Harmon scheduled a hearing. Then his clerk called my office and asked if I could come to chambers for an off-the-record conference. This happens. Judges sometimes want to feel out the landscape before a hearing, where the plea stands, whether a trial is really necessary. The ADA, Linda Corwin, was supposed to be there, but canceled. Harmon decided to proceed with just me. His chambers were on the 3rd floor, wood-paneled, framed diplomas turning yellow. The room smelled like old paper and the particular dust that accumulates on legal volumes no one has opened in a decade. He closed the door, locked it. No court reporter, no recording equipment. This was 2004, 2 years before the state mandate for digital transcription of in-chambers conferences. This conversation would exist only in my notes and his memory. Harmon was direct. He said the case was straightforward. He said he'd looked at the discovery and he thought a jury trial was a waste of the court's time. He asked where the police stood. I told him the DA had offered voluntary manslaughter, 12 to 15. I said that was too high for a first-time offender with a clean record and a victim who had 2 priors. Harmon leaned back in his chair. He said, and I wrote this down on my legal pad, if the DA comes down to criminally negligent homicide, I'd accept it. 3 to 5. The boy doesn't belong in Reedsville for 15 years over a bar fight. Then he said something personal. His nephew had gotten into a fight at a bar in Tybee Island the previous summer. Broke a man's jaw. No charges because the other man swung first. Harmon said, could have been my sister's kid sitting where your client's sitting. I nodded. I wrote it down. In my notes I wrote, H, nephew, bar fight, Tybee Beach, summer '03. I misspelled Tybee Island as Tybee Beach. I do that sometimes. I write fast, and I don't proofread my own meeting notes. Nobody ever reads them but me. The meeting lasted 11 minutes. I walked back to my office and called Linda Corwin to relay the judge's temperature on the plea. I did not call Marcus. I did not visit Marcus. I did not discuss the sidebar with anyone except the ADA. 3rd meeting, October 19th, County Jail, Conference Room B. Same fluorescent buzz, same disinfectant, same hands. Marcus sat down, flat palms. I told him the judge seemed receptive to a lower charge. I was going to negotiate for criminally negligent homicide. Marcus nodded. Then he said, Harmon's going to take it. He told you about his nephew in Tybee. I put my pen down. Not on Tybee, not Tybee Island. He said in Tybee, which is how a local says it. But that wasn't the point. The point was that Marcus Alford, who had been in a holding cell in the basement while I sat in a locked room on the 3rd floor of a building 2 blocks away, was telling me what a judge said to me in private with no record and no witness. I've had clients lie to me for 20 years. None of them ever corrected my notes, because that's what happened next. Marcus tilted his head slightly and said, but you wrote it down wrong. He said Tybee Island. You wrote Tybee Beach. I looked down at my legal pad. Page 14. 3rd line from the bottom. Tybee Beach. He was right. Harmon said Tybee Island. I knew the name. I'd been there. I wrote it wrong because I was writing fast in a room where I wasn't supposed to be taking notes. Marcus knew what I'd written, and he knew that what I'd written was wrong. I closed the legal pad. I asked him very carefully how he knew about my meeting with Judge Harmon. "You told me," he said. "Last Tuesday, right here." Last Tuesday was October 12th. I was in Atlanta for a CLE seminar. I have the hotel receipt. The registration confirmation from the Georgia bar. I signed the attendance sheet at 8:45 a.m. and again at 4:30 p.m. I was 250 miles from the Chatham County Jail. I checked the visitor log later that week. 3 visits under my name, October 1st, October 8th, October 19th. All 3 match my calendar. But October 8th, the visit I remember as our second meeting, the sign-in log shows I arrived at 1:15 p.m. and signed out at 5:20 p.m. 4 hours. My memory says 90 minutes. My parking receipt from the courthouse garage, which I keep because I expense them, says 90 minutes. The jail log says 4 hours, and somewhere in those extra 2.5 hours, something I don't remember happened. I sat in my office that night until the cleaning crew came through. Legal pad open on my desk. I went through every page of notes from the Alford case. 3 meetings, 3 sets of handwritten entries. Meeting 1, standard intake, nothing unusual. Meeting 3, the sidebar quotes, the correction. But meeting 2 is where I lost the floor. Page 11, my handwriting, dated October 8th. The entry I remember writing, strategy discussion, plea options timeline, Marcus's reaction to the involuntary manslaughter offer. 90 minutes of notes, standard. But at the bottom of the page, below a line I'd drawn to separate topics, there was a paragraph I did not remember writing. Discussed Harmon sidebar, nephew, Tybee Island, plea to CNH 3-5. Marcus understands, will wait for DA response. My handwriting, my pen, the same blue Pilot G2, my shorthand, CNH for criminally negligent homicide, 3-5 for the sentencing range, except I didn't write it. I could not have written it. The Harmon sidebar happened on October 15th. These notes are dated October 8th. I wrote about a conversation that hadn't taken place yet, using details. Tybee Island, the correct version, that I would later get wrong in my actual notes from the sidebar. The notation on page 11 says Tybee Island. My notes from the actual sidebar on page 14 say Tybee Beach. I got it wrong after the meeting, but somehow I got it right a week before the meeting happened. I stared at that page until the fluorescent lights in the hallway shut off on their timer. Then I did what any attorney does with evidence he can't explain. Exhale. I turned the page. The plea moved forward. Linda Corwin agreed to criminally negligent homicide, 3-5. Judge Harmon accepted it on November 3rd. Marcus said guilty in a voice so level it could have been reading a grocery list. His hands were flat on the defense table. I gathered my files, case closed, except for everything underneath it. As I packed my briefcase, Marcus, between 2 deputies, turned to me. "The next one's worse, the Drayton Street case." I stopped. "What Drayton Street case?" "You'll see." The deputies walked him out. I stood in the empty courtroom. The clock above the bench ticked too loud for the room. I wrote Drayton Street on my legal pad and went back to the office. There was no Drayton Street case, not in the rotation, not in the DA's files, not anywhere in the system. 6 weeks later, a voluntary manslaughter came through. Victim found behind a bar on Drayton Street. Blunt force trauma. Different defendant, different circumstances, different everything. But the file was wrong. A new case should be thin. Police report, arrest warrant, booking sheet. 50 pages at most. This file was 3 inches thick. Pretrial motions already drafted, depositions already transcribed. A discovery index referencing exhibits I hadn't requested. I'd been assigned the case 40 minutes ago. On the first page, stuck to the margin, a yellow sticky note. 3 words in handwriting that looked like mine, but wasn't. The loops on the D were different. The crossing on the T was higher, but the slant, the pressure, the spacing, someone wrote those words the way I would write them, if I were someone else. The note said, "Check the sidebar." I peeled it off and put it in my desk drawer. The Drayton Street case pleaded out. Nothing unusual. The only artifact was the note. Marcus served 28 months, released early. I never heard from him again. I still have the sticky note. It's in a box now. I've looked at it 100 times. I obtained Marcus's intake forms. His handwriting from booking, not his. Compared it to Judge Harmon's signatures. Not his either. And it's not mine, though I understand why someone might think it was. The recorder's still running. Last day in this office. I'm putting this on tape because I never put it in writing. 26 years of case files in boxes, and the only thing I'm taking with me is a sticky note I can't explain and a legal pad with a paragraph I don't remember writing about a conversation that hadn't happened yet. I don't have a theory. I don't have an explanation. I have a case file that was closed, a client who knew things he couldn't know, and handwriting that's almost mine. The recorder light is red. I should turn it off, but I keep thinking about what Marcus said. The next one's worse. He was right about the Drayton Street case, and I've been waiting 22 years to find out if there's a next one after that. I hope there isn't.